Ending the contract. In this short video, we will consider the various ways in which a contract can be brought to an end. The contract can be ended by performance, so the parties may each perform their obligations under the contract, and once each of the parties has performed their obligations, the contract will come to an end. A contract can be ended by rescission, as we saw in the earlier videos. If one of the parties breaches the contract, the other party may have the right to rescind or terminate the contract. A contract can also be brought to an end by frustration or by agreement, and we will consider these last two ways in which a contract can come to an end in detail. So the first is frustration. In the case of Taylor and Caldwell from 1863, the owner of a concert hall entered into a contract with another person to hire out the hall for the purposes of a performance. Before the date for the performance, the concert hall was burned down by accident. The person who had hired the hall sued the owner of the hall for breach of contract. They argued that the owner of the hall had made a promise to provide the hall for the purposes of the performance, and since they had failed to satisfy their contractual obligation, they were in breach of the contract, and therefore the person hiring the hall was entitled to compensation from the owner of the hall. When the matter went to court, the court decided that this wasn't really an example of breach of contract because the owner of the hall had not actually done anything wrong. The fire that had caused the concert hall to burn down was something that was unexpected and outside the control of the parties, and therefore it wasn't fair to make the owner of the hall responsible for what had happened. The court decided that the contract had been frustrated. Something had happened outside the control of the parties that had made performance of the contract impossible. A contract will be terminated as a result of frustration if 1. A supervening event has made performance of the contract impossible to perform in the way originally envisaged, and 2. Neither party caused the supervening event, and 3. The contract did not provide for the supervening event, and 4. It would be unjust or unfair to compel either party to proceed with the contract. In Taylor and Caldwell, all 4 requirements were satisfied, and the court decided that the contract had been frustrated. The final way in which a contract can come to an end is by agreement. Very simply, both parties can agree to mutually release each other from any future obligations. If one party is unable to perform, it is always an option for them to discuss the matter with the other party, and if the other party is agreeable, both parties can agree that the contract can come to an end early. It is very useful to remember that this is a possible way to end a contract, particularly when you are unable to fully perform your contractual obligations. Before getting embroiled in litigation, it's always worth having a conversation with the other party to find out whether they can agree to bring the contractual arrangement to an end.